Friends, in session number 8, we would cover military law and constitutional courts. And in the process, first few slides would move over the constitutional position uh, in certain articles which impact a military law. To start with, Article 53 that relates to the President of India, and the article states that without prejudice to the generality of the foregoing provision, that is there in Article 52, the supreme command of the defense forces of the Union shall be vested in the President, and the exercise thereof shall be regulated by law. A plain reading indicates that while the supreme command is vested in the President, but how would this be exercised? That would be governed, or that will move in tune with the law framed by the Parliament. Next is Article 74(1), which makes it relationship with the Article 53 clear by stating that the President has to act on the advice of Council of Ministers, and therefore, while performing the role of the Supreme Commander of the Armed Forces, he would be expected to act on the advice of Council of Ministers. Now, one of the powers available to the President is to deal with the offenders that have been tried by courts, and in our context by court martial. Article 72 states that President shall have power to grant pardon, reprieve, respite, or remission or of punishments, or to suspend, remit, or commute the sentence of any person convicted of any offense in all cases where the punishment or sentence is by a court martial. What it conveys is that a person who has been convicted and sentenced by court martial, President shall have the power to grant pardon, reprieve, respite, or remission. And obviously, this he would do so when the case comes to him, having been duly perused and recommended by the Council of Ministers. Now, some of these terms which were there in the preceding article, to start with pardon. Pardon is an official decision not to punish somebody for a crime. Therefore, while the cognizance of the crime may have been taken, thereafter an official decision, obviously by a competent authority, is taken not to punish somebody for that crime. Whereas in the case of reprieve, it is to delay the punishment of someone such as condemned prisoner. It could be anything. Say somebody has been sentenced to imprisonment, or say cashiering. Now that imprisonment or cashiering may not come into effect for some time in case the person has earned a reprieve, in this case from the President of India. Respite is delay in imposition of sentence, but in no way it modifies the sentence. Therefore, sentence remains the same, but its execution or coming into effect is delayed. That is the process of respite. And remission is the reduction in the length of a prison sentence. Now, say for example, somebody has been sentenced to suffer imprisonment for say 4 years, and there may be a remission by 6 months. So ultimately, the period of imprisonment to be suffered by such a convict shall be 3.5 years instead of 4 years, as awarded by a court martial and sentenced and confirmed. Now, in today's context, defense personnel are, with the advent of more education, they are more conscious of their fundamental human and natural rights, even though they are constitutionally denied certain rights, which you had noticed when we did Article 33, the Parliament's power by law to restrict or abrogate certain provisions of Part 3 of the Constitution insofar as they relate to persons belonging to armed forces. Now, what is being implied here is that the presidential power is being increasingly used now by the defense personnel. Earlier, the education was not there, and now this is a major change. Now, moving on, before we go to the powers of the judiciary, the defense of India and every part thereof. I'm reading from the uh, list 1, which pertains to union list. You would see that the 7th schedule states list 1, that defense of India and every part thereof, including preparation for defense and all such acts as may be conducive in times of war to its prosecution and after its termination to effect demobilization, are included in list 1, which is the union list, and the lawmaking power, it is of parliament, which extends to these aspects, and the next entry relates to naval, military and air force and any other armed forces of the union. And this term, any other armed forces, may relate to some other force that may be organized by the union in the days to come. Now, these 4 entries on the slide in front of you all pertain to 7th schedule, which is known as the union list. Now, apart from the words contained in the preamble that I had talked about, the text of Article 33 is sufficiently indicative of the enormity and sensitivity of the role of the armed forces of the Union. And this can be seen in the background that the preceding articles of Part 3, starting and including 15 to 32, provide fundamental rights, and the denial of which can give a ground for a person to move Supreme Court. But insofar as armed forces persons are concerned, Article 33 gives power of Parliament to make law, to restrict or abrogate any of these fundamental rights, to enable due discharge of their duties and for maintenance of discipline amongst them. These are the twin objectives for which the parliament has been empowered to make law, and in fact there are number of provisions that curtail or deny those fundamental rights to the armed forces, which are available to the civil counterparts. After this, we move to the first topic, first slide relating to the topic today, and that is Article 136, that pertains to special leave to appeal by the Supreme Court. And the proviso there says that Clause 1 shall apply to any judgment, determination, sentence, or order passed by or made by any court or tribunal constituted by or under any law relating to the armed forces. Nothing in clause 1 shall apply to this. Now, therefore, the power or the right which is available to the Supreme Court to exercise its jurisdiction by way of Article 136 has got this proviso which restricts its power with regard to the matters uh, of a tribunal which has been constituted by or under any law relating to the armed forces. Now, why has it been so said? Because there may be a tribunal which is constituted under the law relating to the armed forces or constituted by the law relating to the armed forces. So that's why the wordings have been um, put in this manner, and this relates to any judgment, decree, determination, sentence, or order in any cause or matter passed by any court or tribunal in the territory of India that would stand restricted. Now, after the Supreme Court, we see the provision relating to the High Court, and notwithstanding anything in Article 32, every High Court shall have powers throughout, and this we are on Article 226, the territories in relation to which it exercises jurisdiction to issue to any person or authority, including in appropriate cases any government, uh, and it deals with writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari. Now, these are the writs that can be issued by a High Court exercising its jurisdiction under Article 226. Now, this provision is not restricted to the armed forces. But if we move to the next article, that is 227, then I would like to invite your attention to clause 4, while clause 1 says every high court shall have superintendence over all courts and tribunals throughout the territories in relation to which it exercises jurisdiction. Now, High Court has power of superintendence over all courts which are in its territory. But significant is clause 4 for the purpose of this presentation, that says that nothing is this article shall be deemed to confer on a High Court any power of superintendence over any court or tribunal constituted by or under any law relating to the armed forces. Now, therefore, for example, to illustrate, say, take the state of Uttar Pradesh. The High Court of Allahabad has power of superintendence over all courts and tribunals throughout the territory over which it has jurisdiction, that is within the state of Uttar Pradesh. However, the court martial's trial which are taking place within the territory of say Uttar Pradesh, this power would not be available to the High Court to exercise superintendence over that court martial. Another significant feature pertains to judicial review. Now, judicial review is a very significant power available to the constitutional courts, by virtue of which the laws made or the decisions taken by the government in that territory can be subjected to a review. Now, even though the appellate jurisdiction of Supreme Court and power of superintendence of a High Court are excluded under Article 136(2) and 227(4) in respect of armed forces, the Supreme Court under 32 and High Court under Article 226 have the power of judicial review over court martial and can grant appropriate relief if fundamental rights have been denied or if there has been jurisdictional error or any error of law apparent on the face of the record. Now, this was so laid down in S.N. Mukherjee's case in 1990, wherein in substance what the Supreme Court directed was that the Supreme Court and High Court shall have power of judicial review over the functioning of the court martial or the orders passed by a court martial, and they can grant relief and in that manner intervene. Why or when? If fundamental rights of the armed forces have been denied, or the court martial is acting in excess of jurisdiction, where its jurisdiction has been curbed or is limited by statutory provision. However, it continues to do so, then the judicial review can be carried out by the Supreme Court or the High Court. Or third situation is any error of law apparent on the face of the record. So S.N. Mukherjee made it clear that there are three grounds on which the Supreme Court or a High Court concerned can get to examine and interfere with a court-martial verdict, and these three situations are: number one, denial of a fundamental rights; number two, a jurisdictional error; and thirdly, any other error of law apparent on the face of the record. Now, these give an opportunity to the constitutional courts to come and examine the court-martial proceedings, and to that extent, this S.N. Mukherjee's case assumes significance. Other judgment that I would like to invite your attention is of State of Punjab versus Rafiq Masih. This is of 2015. The other one was 1990, so this came up, say, almost 25 years later. And in this, it was laid down that Supreme Court may, in its discretion, grant special leave to appeal, that is, special leave to appeal from any judgment, decree, determination, sentence, or order in any cause or matter passed or made by any court or tribunal in the territory of India. And to that extent, this was also a very significant pronouncement by the Supreme Court in relation to court-martial verdicts. Then the topic which is relevant is of alternative remedy, and in this, D.P. Kukreti's case of 1985 may be mentioned, wherein it was held that when breach of rules of natural justice takes place in relation to the prescribed procedure, then alternate remedy is not an absolute bar to the exercise of writ jurisdiction. Now, earlier it was said that in S.N. Mukherjee, that apparent error in law on the face of the record. And here there is a deviation, or it's a different matter, where the Supreme Court says that rules of natural justice, when they have been lost sight of, which there is a prescribed procedure, and that procedure has been deviated, resulting into breach of rules of natural justice, then the courts will not sit back and say that you go and enjoy your or exercise your alternate remedy. This would not bar exercise of writ jurisdiction. In such a case, writ court can be approached where rules of natural justice have been breached in relation to a prescribed procedure. Now, it can be said in another manner that when Supreme Court would say that you have framed these rules, means the government have been framed under the army rules, say, the rule-making power, and a certain procedure has been prescribed. Say, for example, 96 hours notice will be given before starting trial after the indicated documents have been provided to an accused. So 96 hours period has been prescribed, on active service 24 hours, and in case if this period, which is there for under the rules of natural justice enshrined in the rules, and if these rules are denied, then let it not be said that you have an alternate remedy of a pre-confirmation petition, but then Supreme Court can intervene. Now, this case is of Umashankar Pathak of 1989, and another case is of Kukreti, where notice to show cause against proposed termination of service by authority without jurisdiction is open to challenge. Now, on administrative grounds, it is the central government which can terminate the services of an officer. But disregarding this laid down rule, if a show cause notice for proposed termination has been given by an authority which has not been vested with the jurisdiction, then it can be challenged under Article 226. This was so held by Supreme Court in 1985 in D.P. Kukreti's case. Regarding the matter of habeas corpus, in Sharma's case, it was laid down that Delhi High Court decision, habeas corpus would lie to secure the release of a person from imprisonment under orders of court-martial only on jurisdictional grounds where the court-martial did not have jurisdiction either over that person or over that offense or the sentence in question. So this lack or infirmity in jurisdiction can be with regard to the person, say for example, a district court martial dealing with the case of a junior commissioned officer, or an offense, district court martial dealing with an offense of carrying death penalty, or the sentence is beyond the jurisdiction of that type of court martial. Now, these three may give rise or may lead to habeas corpus where a court can come. Now, the next is fundamental rights in the military legal system. There is no provision of bail which is available to the persons on the civil side. However, after the introduction of Armed Forces Tribunal, the tribunals have been invested with authority to grant bail. And legal aid to accused, Army Rule 97(1) permits an accused to engage a civil lawyer at his own expense or to be defended by a military officer known as the defending officer. Now, therefore, to that extent, the provision of securing legal aid is not at the same pedestal as a person who's a non-military, because he has been guaranteed access to legal aid, which is not here. Here, the provision is in front of you. Now, the position which was there under the Army Act from 1950, when it came into existence, to 2007 was somewhat greatly changed in 2007 when Armed Forces Tribunal came into function, and a meaningful right of appeal was provided to the person subject to the Army Act. Having seen these provisions relating to the position in the Constitution and particularly of the constitutional courts, it needs to be appreciated that a civilized nation cannot ignore the challenges of a remodeling of governance and justice system. Whatever are the new developments and changes, improvements taking place in the form of governance and judicial system in different jurisdictions that permeates to us also, and the facility or the privilege, the right of exercising fundamental rights which is available in the territory of our Indian Republic would slowly increase to and be available to defense personnel also. It's the paramount duty of the government to ensure regular changes, suitable changes, requisite changes in the military justice system so that the course of justice is not perverted. Thank you.